And welcome everyone to the Michigan Supreme Court's December case call. We have 4 cases to hear this morning, and the first one is People versus John Moss. This is a 15-minute mini oral argument on the application. Ms. Pagac, you may attempt to reserve time, but I know you know that we want you to keep track of that, and you may proceed when you're ready.
Good morning, and may it please the court. Christine Pagac, State Appellate Defender's Office, on behalf of John Moss. I am going to attempt to reserve 2 minutes of rebuttal, and this handy clock will undoubtedly help me do that, so thank you. This court should hold that adoptive siblings are not effectively related by blood for purposes of the criminal sexual conduct statutes. First, the plain meaning of blood relative is being descended from a common ancestor. Adoption is not a synonym. Second, the legislature has consistently differentiated throughout the statutes that blood and adoption are different. They keep using those terms to define blood to include adoption here would render those terms superfluous in the other statutes. And finally, it's worth noting that this statute already protects everyone under the age of 16, adopted or otherwise. For better or worse, the legislature has determined that 16 is the age of consent in this state, and the CSC statutes protect everyone under the age of 16 from people in the same household and in positions of authority. So the vast majority of the people that this statute is going to govern are adults. And I think I'm in about 2 minutes, so anytime you want to ask any questions, please.
Okay. Thanks, Ms. Pagac. Let me see what questions folks have, and we can get back to you if they don't. Justice Zahra?
No questions at this time, thank you.
Justice Viviano?
No questions, thank you.
Justice Bernstein?
Hey, good morning, counsel. Welcome to the Supreme Court. Just a quick question, and it's just something I've been thinking about. When a person becomes adopted, there's an oath that they tend to take that the judge administers, and the whole essence and concept of being adopted is that the child becomes yours, and it's seen as though, for all intents and purposes, the child came from within you. It's the idea that the child is it's basically, for all intents and purposes, that when a person becomes adopted, that's your parent, and that is your child. How does this affect that based on the interpretation if this court were to rule in your favor?
Thank you, Justice Bernstein. I think the last time we were here, you talked about that as the spirit of the adoption laws. Yes. Yeah. So I've been thinking about it too. And one thing that, so of course the statutes are protecting everyone the same, and that includes people in the same household. So I think that covers the oath part. But I think you need to think about the flip side of that, which is that if you interpret the adoption code to essentially mean that people become blood relatives, what you are doing then is removing, like you would in, say, the inheritance scheme, you're removing them from the bloodstream. And so then you are not protecting those children from their blood relatives, that if adoption is replacing blood in the statute, then it needs to replace blood in the statute. And so when you have open adoptions, and a lot of adoptions these days certainly are going to involve people remaining connected to their adoptive families, they're not adoptive families, sorry, the opposite, they're blood families. And those prohibitions that the legislature has put in place with respect to sexual relationships with blood relatives, which they did for a variety of reasons, including genetic problems. I think we all are familiar with hemophilia within the royal families. It's that sort of situation that I think is the opposite. And so if the concern is that adopted children aren't getting the same protections once they're over the age of 16, but over the age of consent, then the answer is what it usually is in this circumstance, which is that the legislature needs to include adoption like they have in other statutes.
Okay, and I think you've answered it, but you don't think that this would diminish what it means to be adopted?
No, certainly not. They're protected the same under the age of 16. Like I said, the legislature has decided once you're 16, you can make those sort of decisions for yourself. And at that point, the statute is still protecting people within the same household and from positions of authority exactly the same, regardless of blood or not.
Council, thank you very much.
Justice Clement,
No questions, thank you.
Justice Cavanagh,
No questions for me.
Justice Welch.
I do have one. I'm obviously newer to the bench, so did not have the pleasure of having you both before me the first time around. Thank you for your work on the case. What I am wondering, given I know this has gone up and down a bit, following up, I think, with what Justice Bernstein was talking about. And I know about that there were genetic concerns probably, that may have gone to the root of this statute originally. But it's interesting because the legislature said by blood, and they also said by affinity, which I know this court dealt with the prior time that it was here. But I am admittedly confused because we know there's been interpretations that step siblings are covered by the statute. We know that in-laws are covered by the statute. It admittedly does feel odd that people would, not be treated at least the same as step siblings. And I'm just wondering what your thoughts are on that.
I think, Justice Welch, that gets to the part about marriage, right? And that's where affinity comes in with both in-laws and step siblings. And if you look throughout the rest of the Michigan compiled laws, you'll see that the legislature, when they want to include adoption, says blood affinity or blood marriage and adoption, and they consistently use both blood and adoption when they mean both. And they did not do so here. And if you apply all of the rules that we normally apply with statutory construction, which is to look at the plain language and the plain meaning of the statute, to consider the impact it would have on other other statutes, it would render, like I said, the use of the term adoption superfluous, and a host of other statutes, including some passed very recently, and those are all listed in the brief. The answer really is that the legislature made a determination, and I think partly it may have to do with the fact that it includes adults, two consenting adults. That impacts on now we can feel how we might feel about it, and we might have some different morality judgments, but I don't write the laws, the legislature does, and that's how they need to be applied.
But admittedly, does it seem irrational to have a different set of rules for step siblings versus adopted siblings? I mean, I'm having a hard time rectifying that. Really rationally chose one group over the other.
Like an equal protection concept, the rational basis would be that they use the term affinity, and they did not do so with respect to adoption. That is the legislature's ability to do that, and I think if you start adding, if you're going to say that adoption severs the ties with the family, as the prosecution has suggested, then you are opening up, like I said, the flip side with blood. It is it's much more consistent with the plain meaning of the language to say blood or affinity means what those terms mean, that blood means blood, and it does not include adoption. And that if the legislature intended to include adoption, they would have.
Okay, thank you.
Ms. Pagac, you have 6 minutes. You may continue or reserve, up to you.
I'm going to reserve it all. So
Okay.
Thank you.
All right. Mr. Pierangeli.
Thank you, Justice McCormack. Steve Pierangeli on behalf of the people of Berrien County. The Court of Appeals correctly decided that two people that were adopted by the same person are related by blood for the purposes of the criminal sexual conduct statutes. When looking at the statutes in the criminal code, and interpreting them, they need to be construed to, according to the fair import of their terms, to promote justice and to affect the objects of the law. The criminal sexual conduct statutes went into effect in their current form for the most part, their current form. Passed in 1974, went into effect in 1975. Actually, the same time frame as the effect of order of adoption statute 710.60 going into effect in 1975. And when looking at the intent of the legislature, it should be looked at the time that it was passed, which was in the same time frame as that adoption statute. As indicated in the Armstrong case, the legislature intended to protect young persons from sexual contact by people with whom they have a special relationship. Adoption creates that special relationship. It creates, according to that 710.60 statute, a new family, a new bloodline, as In re Toth put it, as if they're the natural child and those parents are the natural parents. And the fact of the matter is, when you are looking at the CSC statutes, it does not give the adopted child and the natural progeny these same protections. It's even under the age of 16. I can give you an example where it does not give them. We'll just take two children, both one born naturally, one adopted, same exact age. They grow up together. They might as well be siblings for all intents and purposes. Under the statute, they are siblings and blood siblings under the statute. The last time we were here, I know Chief Justice McCormack brought up the creepy uncle example. Not living in the household, may not be a position of authority because that has a specific definition also. So if they're the natural progeny, that creepy uncle has relations with, say, a child 14 years old, that's a criminal sexual conduct in the first degree because it is related by blood or affinity in terms of defense definition of it. And 13 to 15 years old, that would be a CSC first. Under the defense's definition of blood, which goes against, I believe, the statute, that would only be a CSC third just based on the age. So even the ages 13, 14, and 15, those two are not treated equally under the statutes. And when you're looking at the statutes passed during the same time, the legislature included blood. They didn't need to put adoption in the statute because it's already included in their blood with the 710.60.
Thank you. Let me see what questions folks have. Justice Zahra.
No questions, thank you.
Justice Viviano.
No questions.
Justice Bernstein.
Hi, Counsel. Good morning. Just
Morning.
a quick question. In this case, why not just focus more on the elements instead of going to this to the case that you're presenting today?
Focus on the elements in terms of the actual elements of the Moss case?
Yeah, or also whether it was consensual or not. Why is this? Yeah, I mean, this is a very kind of it's kind of an unusual circumstance that you're kind of bringing to the court, and I'm just wondering, why not focus on the other elements of the potential act here as to whether it was consensual or not, in that context.
If the allegations and the charges brought were under alternative theories for the criminal sexual conduct in the third degree. One theory being it was force, non-consensual relations. The other one that it was by blood or affinity within the third degree of consanguinity. The plea, though, was only taken to the relationship part. That's why I did not focus at all on the force, because there was no factual basis taken, and the plea itself, how it was taken, was simply on the relationship. Am I answering your question, sir?
No, you are. You answered it perfectly. I was just really kind of, that's what I was just focusing on is that, why do we have to get into this issue in and of itself?
Yeah, the reason being is because that's what the plea was the blood or affinity aspect of it.
No, I get it. Thank you, counsel.
Okay, sure.
Justice Clement.
Good morning. I'm curious what your thoughts are on Ms. Pagac's her views on whether or not an individual that has been adopted by their adoptee family and has an open relationship with the biological family, is that child now eliminated from this statute's criminal liability with regard to any type of sexual conduct with a member of their natural family?
No, and here's why, Justice Clement. The adoption statute puts them into the bloodline of the adopted family as Judge Shapiro indicated, effectively a blood relationship under that statute. However, even under the Zajikowski case, it talks about DNA. So there still is the DNA aspect of blood, which the courts and the legislature has a public policy to make sure that people that are related still by DNA are not having sexual relations for obviously medical issues and medical reasons. So I don't believe that they escape it because there still is that DNA link under the statute.
So if we were to take your interpretation, they would fall under blood with their adoptee family as well as their natural family.
Yes, there'll be a legal bloodline per the adoption code and a biological DNA bloodline.
Okay, thank you.
Justice Cavanagh,
No questions.
Justice Welch.
No questions.
You may continue, counsel, if you have more to say.
I've learned in brevity, so I will stop at this point. Thank you very much.
Absolutely. Thank you, Ms. Pagac.
I'm not always so good at brevity, so I do have a few more things to say. And I think it gets to the really to respond to I think Justice Clement's point, and I think the earlier example from the last oral argument of the creepy uncle, if you will. What I think the struggle here, right, is that is the desire to protect children, of course, and they are protected by the statute. It might not all be first-degree CSC, but certainly a third-degree CSC charge is a criminal charge. So everyone under the age of 16 is going to be protected. And if it is legally inconsistent to say that we're using the adoption code, which eliminates a child from the bloodline of their natural family for purposes of inheritance and generally, and say, well, we're going to use that definition to make them blood relatives within the CSC statutes, but we're also going to use the plain meaning definition of blood at the same time. To some extent, it's turning the term into blood or adoption instead of just blood. And the legislature has said blood or adoption in a lot of statutes. Ones adopted at the same time, ones that pre-existed, and ones that were adopted very recently. And so if you're going to look at legislative intent, both by looking at what they're doing throughout the statutes, then look no further than the long list of statutes that continue to use blood or adoption. The legislature knows how to say adoption, they do that intentionally. Here, they chose not to do so. Like I said, we may beg to differ with them, but this court regularly follows the plain meaning, follows the basic principles of statutory construction, and says, legislature, we think you need to change this here because you've excluded adoption from the CSC statutes, and we think it should be included. But that is a decision for the legislature. As this court said as far back, well, probably further back, that Bourne cited in the brief. We might make different moral judgments, but those are moral judgments that the legislature gets to make. Are there any questions?
Any further questions for Ms. Pagac? I don't see any, counsel.
Okay, so I have one little wrap-up point. Of course, I'm not going to filibuster for 3 minutes, as delighted as I'm sure everybody would be. Part of, I think, the argument that Brother Counsel is making relies on this affinity definition. I would point the court to both Bliss, this own court's decision, and the much more contemporaneous decision in Denmark for contemporaneous to the CSC statutes in question here. I would note that the legislature has made amendments to the statute and chosen not to put adoption in, but has added other protections. And with that, I would note that I would ask that this court hold that adoptive siblings are not blood relatives and give Mr. Moss the chance to withdraw his plea.
Thank you, Ms. Pagac. Thank you both. The case will be submitted.